I'm Michael Ettinger from Ettinger Law Firm. It's just about 2 minutes after 7, and I'm here to talk about asset protection with the Medicaid Asset Protection Trust, the famous trust set up 5 years ahead of time, protects your home and life savings. This is the first club virtual meeting, hopefully of many, and I'm honored to be the first presenter. And just a little bit about myself. I've been practicing law for 40 years now. Seems like an awfully long time. But most of the time, the last 30 years, it's been just elder law estate planning. And in that time, we've prepared over 25,000 estate plans. So I believe we have a good handle on the types of mistakes people make and how to avoid them. So the next few minutes, it's really intended to make you aware of what's available in terms of asset protection. And I have a slide presentation, which I'm going to attempt to get going here. Let's see if we can share the screen. There we go. There we go. And now go ahead to the share. So we're now screen sharing. If you've just joined us, there's a Q&A button on your, I have to go back. This is going too quick. There's a Q&A button. If you have a question, type it in, and we'll take all your questions at the end. So thank you for joining, and let's proceed. This is Ettinger Law Firm. That's me, Michael Ettinger, my lovely wife and law partner, Suzanne Ettinger, to my left. I'm in the top middle, and the rest of our staff, with 5 offices across the island in Lake Success, Rockville Center, Melville, Huntington, and Bohemia. So what is a trust? It's a separate legal entity that allows you to separate the use and enjoyment of property from the bare ownership. So what you're doing with a Medicaid Asset Protection Trust is you're taking the assets out of your name, but you're still keeping the use and enjoyment of the assets. So you're the trust beneficiary, you have the use and enjoyment of the trust property, and the bare ownership resides in the trust. So it's separate from you, and the trust has its separate tax ID number. This way, if something happens to you personally, like going into a nursing home, they can't get the assets because technically you don't own it. The trust owns it. And the trust has been called the greatest invention of the English common law. So we're separating use and enjoyment from ownership. So you have the use and enjoyment of the home, but you don't technically own it. The trust owns it. And Medicaid can look back up to 5 years. So we put the assets into the trust, and if we need care anytime after 5 years, they can't touch that house. Same thing for assets. So moving on, why did they have the 5-year look back? Because if they didn't have the 5-year look back, everyone would just wait until the day before they have to go into the nursing home and move everything and say, I'm here, take me, I don't have anything, I'm eligible. So they have a 5-year look back. But it's not an all or nothing rule. Let's say you put your house in the Medicaid trust. After 4 years, you have to go into nursing home. You only have to pay for the 1 year that's left. So it prorates. That's why it always pays to get started on the Medicaid Asset Protection Trust, even if you're not sure about your health, you're not sure you can make the five years, you're quite elderly, you still get the benefit of the trust. Some of you may know there's a new 2.5-year look back for home care. So it's 5 years if you need to go into a nursing facility. But what if you want to stay in your own home? And you can stay in your own home, you just need some help. So you need aids. Well, currently the look back is 1 month. So we could move the assets out of our name today, and then on December 1st, we're eligible for Medicaid. There's only a 1 month look back. As of April 1 next year, they're creating a new look back for home care, which is 30 months. And that is going to start to phase in on April 1. And they're going to add a month look back every month until mid-2023, which is 2.5 years later. And after mid-2023, the look back will be 2.5 years, which means if you're home and you need help, you need aids with the activities of daily living, washing, dressing, toileting, transferring, you will not be able to get that help unless the assets have been out of your name in that Medicaid Asset Protection Trust for at least 2.5 years. So the trust is becoming more important because now you have to have your assets in that trust to get home care. Before, you didn't need the trust for home care, only for facility care. So it's an essential tool for those who want to be able to stay in their own home and age in place. Without the MAPT, many will be unable to afford care at home, will be forced to sell their homes and use the money to pay for assisted living. Because if you only have the home and your care costs $1,000 or more a week, you might run out of money and have to sell the house. We don't want that to happen, so we'd like to see you be able to afford to stay in your own home. And the reason we want to be able to get that is you may have a spouse, but statistics show about half of spouse caregivers die first from the strain of taking care of their spouse, which, as you know, is a 24/7, 365 job, and it's a very hard job. So why set up a Medicaid Asset Protection Trust? Well, like all trusts, it avoids probated death. So if you never have to go into nursing home, it still saves more than the cost of setting it up. Your alternatives: making assets joint with the children. Jointly held assets, according to Medicaid, all belong to the parent, except to the extent the son or daughter can prove the amount of their actual contribution, which generally is nothing. Parent just put their name on it, so it's all available for Medicaid. If you transfer it to your children, some people think it's safe by putting their children's name, but then you become subject to all their debts, their liabilities, their divorces, their lawsuits. They might spend it. If they die before you, it goes to their children, etc. So there's no safety in your assets. As I say, they may spend it, refuse to give it back when you need it. If they die before you, it goes to the heirs. You can't transfer it to your spouse. A lot of people say, well, if I'm sick, I'll put in my spouse's name. But Medicaid considers the combined assets of the spouses as all being available for the care of the ill spouse, regardless whose name they're in. The Medicaid trust is known as an income-only trust. So you have to limit your access to the principal by naming somebody other than you or your spouse's trustee. Now, the trustee is the manager of the trust. And if you're the trustee, you can take it out. And if you could get it, they could get it. So you have to pick somebody else, usually one or more of the adult children, and say, because of course, if you can get it, they can get it. So you put the money in the trust and you say, I'm only going to take the income from this trust. So if you have stocks, you only get the dividends. You have CDs, you only get the interest. It's called an income-only trust, and it means what it says. What do you use it for? You use it for your house because you're not spending your house. So you get the right to live there and you keep all your exemptions, senior, veteran, star. But it's ideal for assets that you're not spending. Now, many people tell me that they have a nest egg. Let's pick a number, 500,000. A lot of people tell me, Mike, we don't need that 500,000 to live on. That's extra money just in case. So if you're not spending it, and also some people say, well, we're not spending the 500,000, we're taking the interest or dividends. Well, fine, the trust does give the interest or dividends, but you realize if you have a nest egg that you don't need to live on, you're actually safe keeping it for the nursing home industry. What happens is client is not spending that nest egg, in this case, 500,000. Now they get to 87 or 88, have to go into nursing facility. Well, over at that nursing facility, they're jumping up and down because you're private pay. In any given facility in New York, about 3/4 of the residents are on Medicaid. Is Medicaid paying that nursing home $18,000 or $20,000 a month? No, much less. They just at home run with your money. You're part of the 25% that's private pay that's subsidizing the 75% that are on Medicaid. You want to be the ones that are on Medicaid. And you do that by sheltering your assets in the Medicaid trust. Now, note, it doesn't affect your lifestyle. You still get your pension directly, Social Security directly, interest, dividends, and the required minimum distribution on your IRAs. Your IRA itself, IRA, 401k, 403b, are exempt from Medicaid. They can't get your IRA. They can only get non-IRA money. If it's IRA, they can only get the required minimum distribution. So what are the benefits of the trust? Well, you have the exclusive right to use and enjoy your home. Keep all your property tax exemptions, senior, veteran, star. You might have a brokerage account Your son or daughter, both of them will be the trustees of the trust. Their name will be on the account. Let's say your name is Bill Jones. It'll be son and daughter as trustees of the Jones Family Trust for the benefit of Bill. If you're married to Mary, for the benefit of Bill and Mary, you have the use and enjoyment of the assets. And if you want to continue to operate your investment account, they sign a third-party authorization, say, we authorize dad and mom to trade on the account, and you can run it the same as before. You don't give up control. You reserve the right to change the trustee at any time. So while it's correct they're in charge, you can fire them and put in somebody else, which keeps them on the straight and narrow. It's flexible. The trust can sell the house and buy a condo. In other words, the trust sells the house, the money is paid to the trust. Trust goes out and buys the condo. It doesn't restart the look back period. Similarly, trust can buy and sell and trade stock. So let's say you sell your house for $600,000, you buy the condo for $400,000. What happens to the other $200,000? It stays in the trust, it gets invested, and remember, you get the income from the trust, so you'll get the interest or dividends, whatever that investment throws off. IRAs and other qualified retirement plans are exempt from Medicaid, so we don't put those into the Medicaid Asset Protection Trust. It also preserves the exclusion for the capital gains tax on the sale of the principal residence. So you put your house in the trust. You may know that when you sell your house, if it's your principal residence, if you're a couple, you can exclude $500,000 of capital gains. A single can exclude $250,000 in capital gains. So you get the exclusion, even though you put in the trust. Now, you may know that the Medicaid trust is an irrevocable trust, but we don't make such a big deal about it because in New York, you can revoke an irrevocable trust. And here's why. It's an irrevocable trust because you, the people set up, you're called the grantors. There's the lovely grantor couple there. You can't revoke it yourselves. So law says, as far as you're concerned, that's an irrevocable trust. But New York has another rule on the books that says that if all the parties named in an irrevocable trust agree in writing that they no longer want the trust, you may revoke it on consent of all the named parties, which is you and your children. So if everybody signs, you can undo it, and that's not a hard thing to do. However, you know, there might be a case where one of them won't sign, not a problem. There's a workaround. We can amend the trust, take that son or daughter's name on it. Take their son or daughter's name out of the trust, and now they're not a party to the trust, so you revoke it on consent of everybody else. So you really can undo it if you want to. So how do you keep control with an MEPT? You can buy and sell assets. You keep your property tax exemptions. You can change the trustee at any time. You can change who you leave it to. So even though it's an irrevocable trust, you reserve the right to change who you leave it to, which is useful because things change. And now I said you can't take out principal. Remember, it's an income-only trust. But what if you need money? What if you need $50,000 for something? Well, you can't take it out directly because if you could get it, the nursing home can get it. But you do have a gifting power. In fact, it's an unlimited gifting power. You can gift any amount from the trust to your son or daughter. Because when I apply for Medicaid, they're going to ask me, what did you take out of your name and put into that trust? But they're not allowed to ask me what the trust gave to somebody else. So let's say you need $50,000 to take your whole family on a trip around the world. You make a gift from the trust to your son or daughter. Now they can't give it back to you. Because again, when I apply for Medicaid, I have to show them all your investment accounts, all your bank accounts for the last 5 years. If they see 50,000 came in, they're going to say, where did that come from? And if it came from the trust to your son, so they can't give it back to you. But can they take that 50,000, go pay the travel agent for the trip? Well, of course, it's their money. They can do whatever they want with it. So you hand them the bill, they pay the bill. So backdoor, you can get money, principal through the gifting power, make a gift to them, and they pay the bill. And we know we can always revoke the trust on consent of all the named parties. So you have a lot of control with a properly drafted Medicaid Asset Protection Trust. Every Wednesday at 2 o'clock, which is tomorrow, just technical glitches here. Hopefully get that to stop. I give a full-blown seminar, the 4 reasons why trusts protect you better than wills. And we've been doing this type of work for 30 years. We've preferred trusts over wills. And just give you a quick overview. Trusts avoid probate at death. You may have heard of that. Trusts avoid guardianship if you become disabled. We go into that in detail. Trusts help you keep your assets in the bloodline. So it goes for grandchildren and away from in-laws and their families. We'll talk about how trusts protect the inheritance you leave from children's divorces, lawsuits, and creditors. And again, keep it in the blood. And then I'll give a full presentation on this irrevocable Medicaid Asset Protection Trust. And also, we offer a free consultation, which is worth $500. It's free, but some firms charge. And it's very simple. If you're on this video, you will get an invitation tomorrow, I believe, once we work out all our kinks. It's opening night here. You'll be invited to make an appointment. Prefer you watch the seminar tomorrow too. Register at ettingerplan.com. You can always call Patty Brown, our firm manager for more than 25 years, at the number on your screen, or email her pbrown@trustlaw.com. She can answer any questions that you have. So now, let's see where we are. There we are. I wonder if we have any questions. Does anybody have any questions? If you do, you can post them. If you don't, I will tell you about next week. Next week, we are going to have at Club Virtual, Dr. Charles Thompson from Clarity Surgical. He's going to discuss weight loss options for people who have difficulty losing weight and keeping it off. And that's so many people. So I think a lot of people will be interested in the Clarity Surgical presentation. I'll be back in 2 weeks when we have maybe a little more practice with this new system. And I'll have a slide presentation on the 5 steps to an elder law estate plan. You can sign up on any of the Conister radio station sites as you did for tonight's session. And now a couple of questions have come in. Tom L. asks, can someone have both a living trust and an irrevocable trust? Well, Tom, generally not. Once you have an irrevocable trust, you have to put most of your assets into that trust. Otherwise, it doesn't benefit you. If you leave too much out, you're going to be paying out of your pocket instead of being eligible for Medicaid benefits. So the amount you leave out of the irrevocable trust is not enough to set up a living trust for. Generally, what you leave out of the irrevocable trust, you make joint with somebody or put a beneficiary on. So no, very rare that you need both. And Anonymous says, hi, if my home is transferred into an irrevocable trust, can it be sold? Well, you know, that's a very good, you're welcome, Tom. That's a very good question. You know, I'm amazed how many people come into my office and say, somebody told me that if I put my house into an irrevocable trust, it can't be sold. And that's, you know, I tell them, well, you know, that's strange. You know, we've done it thousands of times. It's just incorrect information. And at any time, the irrevocable trust can sell the house. The money's paid to the trust. Trust can buy another house. So be careful about the misinformation. You know, at my website, trustlaw.com, I have about 100 articles on estate planning, articles on the Medicaid trust. And I have an article there. My website is trustlaw.com. And under practice areas, I have an article. I wrote an article called The 7 Myths About Irrevocable Trusts. And one of the myths is you can't sell the house, a myth. One of them is you lose your exemption, senior veteran star, a myth. So get your information from an elder law attorney, and you're going to not fall for any of that those myths that people. I believe that there are thousands of people over the years who were told, oh, if you put your house into Medicaid trust, you can't sell it. They didn't put the house in the trust, naturally, who would? And they ended up losing the house because it wasn't protected. So get your advice from an elder law firm. Anonymous says, my neighbors told me that I don't need a trust. Is that right? And I wonder what law school your neighbor went to. They put their children's names on their deed instead. Okay, let's talk about the deed with the life estate. If you deed your house to the children and you reserve the right to live there, the house is exempt from Medicaid. However, there are a number of problems with that. And here's the reason why we don't do that very often. You remember I said a few minutes ago that if you sell your house, you have the exclusion from the capital gains tax, $500,000 for a couple and $250,000 for a single. Well, if you put your house in the kids' names, not your house anymore. So you want to sell the house, which naturally you get older, you might not want to keep it up. You might need assisted living. You want to sell the house. You lost the exclusion for the capital gains tax. The other thing is you give up control, which I don't like my clients to give up control. And by that I mean this. If I put my house in the trust and I want to sell it and my son or daughter says, no, I don't agree, you say, you're fired. I'm putting your brother in or your sister in. You still have control. But what if you deed the house to them and their name is on the deed and you want to sell it? Their name's on the deed. You can't sell it. You can't fire them. They're actually an owner. So if they don't sign, you can't undo it. And I've had people come to me over the years and say, I want to sell the house. My son or daughter won't sign. I said, there's nothing you can do. The lawyer painted you into a corner. I won't do that. There's a couple of other disadvantages. If you have to go into nursing home and you decide to sell the house because it's empty, the life estate has a value, generally around half the value of the house. So you sell the house while mom or dad is living, half the money goes to nursing home. You actually have to carry the house empty until mom or dad dies. It could be many years because if you sell it, half goes to nursing home. So it's only protected if you keep it until they pass. And then you say, well, I'll rent it. Well, if you rent it, the rents go to the life tenant. So the rents go to mom and dad, which means the rents go to the nursing home. So I don't like the deed with the life estate. There are so many drawbacks, but the lawyer who did that was not an elder law estate planning attorney. There was a general lawyer who knew how to do a deed, but that general lawyer is not a tax lawyer, not a estate planning lawyer. So he doesn't know. Those clients don't know that if you sell their house, they lose the exclusion. They don't know they can't sell the house if they have to go into a nursing home. They don't know if they rent the house, the income will go to the nursing home. So there are a lot of disadvantages. It's not a good idea. And if you tell them they can come in, I can review it and I can fix it. Actually, we fix a lot of those because people are just very upset when they find out all the disadvantages. Anonymous owns a condo in Florida. How can I protect it? Well, Anonymous, if you live in Florida, if you move there, the condo is exempt because they have the homestead exemption, but only if you reside there. It has to be your house. If it's a vacation home, then we have to put it into the New York Medicaid Asset Protection Trust, which will do two things. It'll protect it from Medicaid here in New York, but also will avoid the multiple probate problem. If you die in New York and you own the condo in Florida, we have to probate the estate in New York and Florida, 2 probates, 2 fees, 2 lawyers. Not only do you pay twice, but it takes twice as long because I have to probate New York before I can probate Florida. So they come one after the other. And Ellen L says, is my mom's boyfriend entitled to stay in her condo if God forbid she passes before him? It's only in her name. Absolutely yes, Helen. If he's living there, he has rights and you have to evict him. He's a tenant at will. You have to give him a 30-day notice. And then if he doesn't leave after 30-day notice, and you can prove you served him with a 30-day notice, you can commence an eviction proceeding. So yes, he has rights, absolutely. Even if it's only in her name, he has tenant's rights. Jimmy Jones. Oh, I'm sorry. I don't really mean to mention the last name, just the last letter. Jimmy J. Although I spilled the beans already. What happens to my trust if I move to another state? Jimmy, the trust is portable. As long as it's valid in the state you created, which is New York, it's valid in any state because of the full faith and credit clause of the U.S. Constitution. Each state must respect the laws of each other state. So that looks like it. If you have any more questions, type them in. Otherwise, I'm going to invite you to join me at ettingerplan.com. Register for my seminar. It's tomorrow at 2 o'clock, Wednesday. And if you're not going to be around at 2, if you register anyway, you get the recording so you can watch it at your leisure. So I want to offer my congratulations to Connoisseur Media for providing this public service. And it's just the beginning of what we hope to be a very successful venture, bringing valuable information out to the public. So thank you for joining, and I wish you all a good evening. Stay safe, everyone. And I hope to see you in a couple of weeks when I'm going to present again the 5 steps to an elder law estate plan. So good night and be well. Thank you.